Hello and welcome to the Wayne County Probate Court. This video will guide you in filling out the testimony to identify heirs, form PC 565. Before we get started, this video is not legal advice and is for informational purposes only. Please seek legal advice for specific questions regarding your situation. So let's get this form and start filling it out. The court's website is www.wcpc.us. When you get there, in the upper middle, it's probate information. When you click that on the left, how to start a Wayne County probate case, click that. You'll see the various case types. I'm going to pull the form from the decedent's estate application. When I click on that, about halfway down in E is form PC 565, which is described here as testimony for interested persons. The form itself is called Testimony to Identify Heirs. When you click on the link, the form pops up, which you can use to start filling it out right on your computer. I have an annotated one to help guide through filling out the form. Before we start filling out the form, I highlighted heirs. Just real quick, the definition of an heir is someone who is entitled to receive an intestate decedent's property. So if someone died intestate without a will, the statute, EPIC is the name of the statute, and it lists out who would be entitled to the decedent's property. And then up above, broadly speaking, this form is telling the court who has an interest in the estate's property. So that's in general what this form is trying to get out about the decedent. So let's start filling it out. In the upper left, Wayne County, you'll type in Wayne. On the right, you'll leave the case number and judge blank if you're filling this out as part of an application or a petition. But if you have the information, then fill it in. Put the court address and telephone number, which is on the website. Fill in the name of the decedent, and then fill in the name of the person in number 1 who is filling out this form. It doesn't have to be the applicant or the petitioner, but it's just whoever is filling this form out. Name and address, your relation to the decedent, the date and time of death, and their address at the time of their death. Moving on to 4. Just above that, you'll see that a note says anyone who died within 120 hours, which is 5 days, of the decedent is not considered an heir. So there's a statute in EPIC which says that you treat anyone who died within 5 days, 120 hours of the decedent, as if they died before the decedent, and therefore they would not be heirs. So if spouses died in a car crash, both of them would be considered to have predeceased the other. It's a little confusing, and if this applies to your situation, I strongly recommend you hire an attorney to help with this form. But moving on to 4, the decedent did not leave a surviving spouse or left a surviving spouse. You'll check the applicable blocks, and then if there is a name, you'll fill that in. 5A, the decedent had the following children, both natural, born in or out of wedlock, and adopted. You'll type in the name if this applies, and you'll also check box 5A. 5B, of the children listed in 5A, the following are no longer heirs due to their adoption by someone other than a step-parent. If a child was adopted and this is applicable, check box 5B and type in the name. 5C, of the children listed in 5A, the following were not children of the surviving spouse. So obviously, sometimes people get remarried, have kids with a previous spouse and a current spouse. If this is applicable, check box C and type in the names. 6. Answer question 6 only if question 5A was checked. So if it wasn't checked, do not fill this in. 6A says the following children listed in 5A died before the decedent. If this is true, check this box and type in the names. B, the children listed in 6A left their own children or left grandchildren from one or more of their own predeceased children who survived the decedent. The names of these descendants and the name of the child in 6A to whom they were related are as follows. So a little wordy, but if a child died before their parent, but also left children, this is the type of information that 6B seeks to understand. 6C, of the persons listed in 6B, the following are no longer heirs due to their adoption by someone other than a step parent. So perhaps a child was adopted, in which case you'll mark 6C and put in their name. Moving on to page 2, number 7. If decedent left no surviving descendants, complete 7. So this may not apply to your situation, so you may just leave this blank. But if it does, you'll check the appropriate box. The decedent did not leave surviving parents or left a surviving parent named. And again, broadly speaking, this is trying to figure out who is entitled or has an interest in the decedent's estate. That's why it is asking all these questions about who's alive, who's adopted, and in general, who has an interest in the estate. So number 8, if decedent is not survived by spouse, descendants, or parents, complete 8 and 9 if applicable. So again, you may not need to fill this out if it doesn't apply to you, but number 8 says the decedent did not leave surviving brothers or sisters or left the following brothers or sisters, either natural or adopted, whole blood or half blood, who were not adopted by others and who survived the decedent. Check the applicable box and type in the names. Number 9, one or more of the brothers and sisters in the decedent died before him or her leaving descendants, natural or adopted, who were not adopted by others and who survived the decedent. The names of these descendants and the names of their deceased ancestors are. So again, getting pretty remote, but if this applies, check box 9 and type in their names. Number 10, if decedent was not survived by spouse, descendants, parents, brother or sister, or children of deceased brother or sister, complete 10. The decedent did not leave surviving grandparents or left surviving grandparents named. Number 11, both maternal grandparents and or paternal grandparents died before decedent. Their surviving descendants and their relationship to the grandparents are. Check this box if it's applicable and fill in the names as appropriate. Number 12, the following heirs listed above are under legal disability and are currently living. Their names, legal disability, and names of their representatives are. So this was also asked in the application, and it says, or is looking to understand if any of the heirs are under a disability such as a guardianship, conservatorship, or a minor, and who is the representative of those people. So if it's true, check box 12 and fill in the names, the legal disability, and the representative. If there are multiple people, you can simply type C attached and put an attachment to this with the names requested in number 12. Number 13, the following deceased heirs survived the decedent by more than 120 hours. Their names and the names of those who represent decedent's interests are. So this might be someone who died after the 124-hour cutoff period, but are currently dead now. If that's true, you'll check box 13 and fill in the names. Box 14 says the following persons identified above did not survive the decedent by 120 hours. Their names, legal relationship to the decedent, and the date and time of their death are. So if anyone died within that 120-hour period, enter the name and other information here in box 14. Okay, last page, number 15. The decedent left a will, and then check the applicable box. All devisees are heirs. So a devisee is someone who is entitled to receive property pursuant to a will, whereas an heir is someone who is entitled to receive property pursuant to the statutes. And so sometimes someone is entitled to receive pursuant to a will, even though they're not an heir. So if the second box applies, some of the devisees named in the will or codicil are not heirs of the testator. You're going to need to fill out form PC 566 and include that as part of the application or petition. And real quick, a codicil is an amendment to a will, and that may be applicable to your situation. So after you check the appropriate box, you're going to read the declaration. If it's true, you're going to date and sign. An e-signature is acceptable. And then if there is an attorney involved, they must sign as well. If there's no attorney involved, then an attorney does not have to sign this document. But as you can see, depending on your circumstances, this can get complicated. You may want to hire an attorney if your situation is a little more complicated than most. So thank you. Hopefully this was helpful. We here at Wayne County Probate Court put this video together because we care. Have a great day.